I would have answered these on the morning ramble, but I guess it's fine that it didn't work out. Apparently, the microphone was clanking against the zipper on my hoodie the whole time. Super annoying. So I'm not going to make you sit through that. State v. Kelly. This was a question asked on Discord. That is the best way to get a hold of me. I'm not always available on it, but I'll see it because I do check Discord at least once a day. So the context is that somebody thought that State v. Kelly upheld the proposition that police safety, officer safety, trumps the Fourth Amendment. Some basic facts are State v. Kelly is a Connecticut state Supreme Court decision. It is not federal, so it would only be applicable in Connecticut. There's not a huge amount of preference shown to other states' courts' determinations of federal rights, surprisingly enough. Pretty much the federal courts get to determine what your federal and constitutional rights are, and the state courts will typically only look at those, at the interplay between those and state rights, and it doesn't really translate well across state lines. In State v. Kelly, there were two guys walking down the street. Cop saw one of them, thought he was Pedro Gomez, a wanted person. So they were going to snatch up this other guy who wasn't Pedro Gomez, somebody named Burgos, I think. Anyway, Mr. Kelly was with him, and Mr. Kelly decided to take off running. Now, that's probably not a good idea, just saying, especially if you've got baggies of Coke on you. He threw one baggie. He was found with another baggie on him. He tried to get it suppressed, saying that the police didn't have reasonable suspicion, so he shouldn't be, all the evidence should be suppressed because it was obtained unlawfully. And number one, they still use the reasonableness test, the same reasonableness test in this article, at least. The way this article phrases it, they use the same reasonable test they've been using ever since Terry v. Ohio, maybe even before then. But if you remember, in Terry v. Ohio, Officer McFadden suspected the guys of planning an armed robbery. If you're going to commit an armed robbery, you are, by definition, armed. So he had reasonable suspicion to believe they were armed. He patted down their coats. It was a relatively minor intrusion, or so the Supreme Court held. And officer safety is a factor in making the determination on whether or not a search or seizure is reasonable. And so ever since Terry v. Ohio, the officer safety has been a portion of the reasonableness test. But the fact pattern is very reminiscent of Illinois v. Wardlow, at least as far as I am aware from this article. I couldn't find the actual case. Now, I don't like going off of articles. I typically won't if I can at all possibly help it. The reason why is because it adds in a layer of bias and another person's potential mistakes on what is or isn't important or how to interpret a particular ruling by the court. So I don't much cotton to relying on articles. If you need to, that's fine. I know some of these cases can be confusing, and it can help to read an article by someone who knows what they're talking about to kind of get an idea of what you should be looking at, and then you can go back and reread the case. But the second part of that is very important. Go back and reread the opinion. Make sure that what was told to you was actually presented in the case. It'll also allow you to clear up what is the opinion of the author of the article versus what the opinion of the judges are. So there you go. I hope I've answered your question. I probably didn't. I probably just rambled too much. Second question was on Hague v. CIO and the potential. The question was whether or not it's really precedential. And yeah, it's very super duper precedential. The reason why is because there were two judges plus a judge who's concurring in part and dissenting in part that clove to the majority decision. The one who concurred in part and dissented in part in part, also wrote his own concurring opinion. Then two other judges wrote a concurring opinion. And then the final two judges wrote dissenting opinions. And you're going to say that adds up to 7, not 9. Two judges didn't participate. So the one with the two opinions plus a person concurring in the opinion made the majority. The only part of this test, though, that is of the case that's really important is this part, the time immemorially been held in trust since time out of mind. There we go. This is the only real important part of it. You can always tell how precedential a case is. Court listener, if it's listed on court listener, will tell you how many cases cited it. A better way would be to go to the law library and type this into LexisNexis and click on the old Shepherd button, and it'll show you all the cases that cited it, all the cases that were cited it favorably, all the cases that cited it negatively, and any cases that may have distinguished it. All those are fun and important, but the part that is going to last is this little bit here. And it's going to last because it's been cited in Supreme Court decisions. It's been cited in innumerable lower federal court decisions. Let's see, clear all. And we just want Supreme Court. Apply. It's been cited in 123 Supreme Court decisions. 123. It is super precedential. I think what the confusion is that some people think that, oh, it was a close Supreme Court decision because it was 5-4, or in this case, it was 3, or like 2.5 plus 1 plus 2. V2. I don't think it really works out. I don't really think the number of judges who vote in favor of the majority opinion really matters. As long as there's 5, or as long as there's a majority, I think you're good. It's not very common that the court overturns things. They may distinguish it away, chip away at it bit by bit until they're just left with the good portions of the case. And if the good portions of that case aren't really useful, maybe the good portions of that case are better supported coming from other cases that haven't been whittled away, then they'll, stop relying on that case that's been distinguished away. What I'm saying is that the number voting for it don't really matter as long as it's majority, in my opinion. And this is just an opinion based on my observations of the way these things work. The shepherdizing feature of LexisNexis would tell you a lot more. It would tell you what cases, and anyway, but it's very precedential. If you have over 1,000 cases citing you, if you have 1,000 cases citing, over 1,000 cases citing your opinion, if you have 123 Supreme Court decisions citing your opinion, it's a good opinion. And the part that they keep citing is going to be, let's do this by newest first. Let's see what we got. (2010) Bolosky v. Kapos. I haven't clicked on this. Oh, there's 2 of them. We're going to do this one. There's 2 of these. Let's see if they're both the same. They might be the same, but I don't want to necessarily risk it. So there's only one of these. All right. There's language. There's language. Now, they're quoting this out of Perry Education Association, quoting Hague. But There you go. There's the language. That's why I say this language is important, because it appears in 120 some odd Supreme Court decisions. Kids these days. So one other thing, quick note, is if you find a lone case, if all the cases that you're finding are against the position you want them to find, and you keep hunting and you keep hunting until you find the one case that seems to say what you want it to say, be very skeptical about it. You may be missing something very key, very minor in it. I just had a case get resolved. It was a domestic violence restraining order case where opposing counsel relied very heavily on Fisher v. Fisher, a brand new California appellate decision, and they missed one sentence in it. Let's see if we can find it. There we go. They missed one sentence in it. Oh, that's right. That's right. All right. So it was at the bottom of the page. They missed this sentence right here. He was not worried for his safety. That sentence right there just screwed the pooch for him. The basis for getting it, I should explain. The basis for getting a domestic violence restraining order, you get the temporary one if you just show basically, yeah, I was abused. If you can convince the judge in an ex parte hearing that you were abused somehow, then you get the temporary one. But then eventually you got to go to court, because you're taking away somebody's right to bear a firearm. In California, you can't own a firearm. Well, you can own it, but you can't have it in your possession. You have to turn it over to like a gun store or something like that. So it's a pretty big imposition on your liberty to have that domestic violence restraining order. So you get a full and fair hearing, as Mr. Freeman likes to say. And the problem in this situation, I was representing petitioner, opposing counsel was representing respondent, and the respondent was trying to use Fisher v. Fisher to say that there was no good reason for petitioner to get we were actually looking for the permanent. But so there was no reason for the petitioner to get an extended restraining order. In California, it's 5 years or permanent, but I've seen courts drop the time to like 3 years. Anyway, the vast bulk of the cases out there were against the position they were arguing. And I have a feeling that basically out of desperation, hoping that the judge wouldn't read it or I wouldn't read it, they threw out Fisher v. Fisher, and they were quoting all sorts of language in Fisher v. Fisher that looked, I mean, I actually did have a sinking feeling when I was reading their response, their reply, or the respondent's trial brief. That's the document it was submitted on. And I was having heart palpitations because a brand new case out there that seemingly was undercutting all this existing case law. And, you know, it was palpitation city. And then I read it and I found this one sentence: he was not worried for his safety. And that killed it for him. So if you think you find a smoking gun, if you think you find that one case that supports your position, in spite of the overwhelming weight of cases that are against your position, you're probably missing something. And I'm saying this because I constantly get people who find a decision that they think is on topic, but it's not. Like when Mr. Freeman was throwing out a Fourth Amendment case, thinking that it was somehow related to the First Amendment because it mentioned privacy in public and therefore, et cetera, not understanding the case. There's a reason why. That's why I'm saying just be very careful. Precedent is important. Having a brand new novel, something entirely out of the blue, is very uncommon. So thanks for watching. Have a great day.